Well, already, gang, welcome back to the Gutowski Files, starring Stephen Gutowski.
Wilderness Tactical has been around for longer than the gun you're carrying has been, and they have been making high-quality products for concealed carriers for literally decades. I wear their low pro belt every year. The webbing is the best in the industry, and I won't wear anything else. If you're looking for a good CCW belt, check them out.
He is the founder of thereload.com and the host of the Weekly Reload podcast. Stephen, how are you, sir?
I'm doing pretty well. Been very busy. The weekend had a lot of news for us to talk about.
Indeed, and heartache for you, but we'll talk about that at the end.
Gosh, we don't need to talk about that part.
Yeah, we don't talk about that at the beginning anymore. The S word. Anyway, so there's a lot going on. It's been a busy week in the firearms world, and for those of us paying attention to the firearms related news and the Second Amendment related news. So let's start with California. We talked about last week about this case out of California. There's been a significant development. My question is, I'll let you talk about it, is this now a done deal, or is this just another sort of temporary measure? Tell the folks what's going on out there.
That's a very good question, because what happened was the motions panel was reversed by the merits panel. Now, I know this probably isn't going to make any sense to anybody who isn't a lawyer or very well versed in how the federal court system works, but we talked about earlier how the California's new gun-free zone expansion law, SB 2, that sort of effectively banned all gun carry in the state, essentially put in so many of these restricted areas, these sensitive places, that in practice it would be almost impossible to carry your gun, even if, and this applies to people with concealed carry permits, it would be practically impossible to carry it on you without running into one of these gun-free zones where
right.
If you carry there, you could be charged with a crime. But that law was found unconstitutional, right? We talked about that. The federal judge said that it was incompatible with the Second Amendment and the Supreme Court's precedent on gun carry that was handed down in the Bruin case, right? And then what's called the motions panel, the state appealed that decision, right? And it went to this thing called the motions panel, where they sort of are a go-between for the actual panel that is going to decide the case at trial, the merits panel. Mm-hmm. And the motions panel granted an administrative stay on this ruling. And this is all, I know that all sounds like legalese, but the practical impact of that was very big, because what it meant was the law, which had not gone into effect yet when the lower court gave down its ruling, essentially preventing the law from going into effect at all and keeping things as they had been up to that point. But on January 1st, the law was allowed to go into effect. So all these gun-free zones became enforceable at that point because of this stay that had stayed the ruling of the lower court. And we have, that was huge, because California, obviously the largest state in the country, a place where people outside of, more rural areas had only just begun to have the ability to get permits to carry in the first place because of the Bruin rule, because that forced the state to change how it issues permits. And now those people would effectively be back to a place where they aren't allowed to legally carry because of an administrative stay. Now, what happened after that was we heard from the merits panel on Saturday. So these things have all, one of the motions was filed on Christmas Eve night. And then now we have this reversal of the stay that was put in place, and that happened on Saturday. So the courts are actually working pretty quickly and at odd times to do this case. So that kind of gives you an insight into how important they think it is. But the practical effect now is that the lower court's ruling is back into effect. This law is unconstitutional, according to that lower court, and can't be enforced as the appeals move forward. Now, it could, as you sort of alluded to here, there is a possibility that it could be reversed again, and they might issue some kind of stay. That came from the order itself, said that, this is pending, future decisions from the panel. Would be, I think it's unlikely that you're going to see it get reversed, have the stay go back into effect.
Double secretly reversed.
Yeah, there's just so much legal whiplash going on over this that I would be surprised if they did anything again until actual oral arguments begin in April. So it does seem like for the next couple of months, at least, you're going to keep that status quo, because the status quo in this situation was not having this law in place like that. The lower court judge ruled before the law went into effect. So all his ruling really does is keep things as they were. So these sorts of expanded gun-free zones weren't around before January 1st. And so after being placed for about a week, they're back off the table. And we also might see this case get combined with some other ones. There's a case out of Hawaii where there was a similar lower court ruling that blocked most of the sensitive places restrictions that Hawaii had put into place, these sort of gun-free zones. And so that's also scheduled for April, and it would be pretty surprising and that's also in the Ninth Circuit, which is where this California case is, would be pretty surprising if they didn't get combined into one case, but that hasn't officially happened yet. But that seems to be the direction things are headed. And yeah, pretty significant, though technical, rulings going on here.
Indeed. So folks who are listening in California, please do not take this show as any kind of legal advice. Terms and conditions may apply, all rights reserved. Don't make sure you check the actual situation on the ground there before you carry or don't carry or make a decision, because as you've seen, as you heard from what Stephen had to say, it changes rather frequently, unfortunately. Hopefully this will stay the status quo until the actual trial begins.
You got to keep up to date with all this stuff, because that's another thing that could absolutely happen. This is not a final ruling. None of this is a final ruling. The judge blocked the lower court judge, on a preliminary injunction basis, which is before the actual technical merits of a trial happen. Now, to get that ruling, the judge has to find that the plaintiffs are likely to succeed on the merits. So that's why often it can be kind of confusing to listen to this stuff, because it's very, if a judge rules you're likely to succeed on the merits, then he's probably going to rule that you did succeed on the merits once the case gets to that point. But it's not actually at that point yet.